No guilty act, no crime. That's the golden rule of criminal liability. But act covers far more than just pulling a trigger or throwing a punch. Let's unpack exactly what Actus Reus means. Actus Reus is the external, physical element of a crime. Think of it as the hub of a wheel with several spokes, voluntary acts, omissions, states of affairs, and causation all radiating outward. Get any spoke wrong, and the prosecution's case collapses. The starting point is that the defendant's conduct must be voluntary, meaning the defendant must have conscious control over their body at the relevant moment. If D acts in a state of automatism, whether from a reflex, a seizure, or an external blow, the act is not truly theirs and no actus reus exists. The court in Hillforth v. Baxter, 1958, gave vivid examples. A driver stung by a swarm of bees or knocked unconscious by a stone is not acting voluntarily. The key word is control. D must be the conscious author of the physical movement. English law takes a firm position. There is no general duty to act. You can walk past a drowning stranger with complete legal impunity, morally troubling but legally true. However, liability for omission does arise when a specific duty to act is recognized by law. The concept is important precisely because the duty must be established before the omission can even qualify as an actus reus. Without the duty, there is simply nothing to prosecute. There are four main duty sources. First, statute. Parliament can expressly impose a duty, as in the Road Traffic Act 1988, which requires drivers to report accidents. Second, contract. In Pitwood, 1902, a railway gatekeeper failed to close a level crossing gate as his contract required. A man was killed, and the gatekeeper was convicted of manslaughter. Third, voluntary assumption of responsibility. In Stone and Dobinson, 1977, the defendants took an infirm relative into their home and assumed care for her. When she died through neglect, they were convicted because by assuming that responsibility, they had created the duty. Fourth, the creation of a dangerous situation. In Miller, 1983, a squatter accidentally started a fire and, on realizing it, simply moved to another room rather than raising the alarm. The House of Lords held that once you create a dangerous situation, you're under a duty to take reasonable steps to address it. Some crimes are committed not by an act or omission at all, but simply by being in a particular situation. These are called state of affairs crimes, and they are controversial precisely because they require no willed conduct whatsoever. In Larsonneur, 1933, a French woman was deported to Ireland against her will and then forcibly brought back to England by Irish police. She was convicted under the Aliens Order simply for being found in the UK without permission, even though she had no control over her presence. Similarly, in Windsor v. Chief Constable of Kent, 1983, D was removed from a hospital and placed on the public highway by police, then immediately arrested for being found drunk on the highway. The courts upheld both convictions despite the absence of any genuinely voluntary conduct. In result crimes, those where the law requires a specific outcome, like death in murder, it is not enough that D did something bad. That conduct must actually have caused the prohibited result. Causation splits into two stages. Factual causation uses the but-for test. But for D's act, would the result have occurred? If the answer is no, factual causation is established. In White's for 1910, D poisoned his mother's drink, but she died of an unrelated heart attack before drinking it. No factual causation, so D was acquitted of murder. Legal causation then asks whether D's act was a substantial and operating cause of the result, not the only cause, but more than minimal. Paget, 1983, confirms D need not be the sole cause. The chain of causation can be broken by a novus actus interveniens, an act of the victim, a third party, or a natural event, but only if it is sufficiently independent and overwhelming to make D's contribution negligible. It helps to draw a clean line between two categories of crime. Conduct crimes are complete the moment D performs the prohibited act, dangerous driving or perjury, for example. The actus reus is the conduct itself, regardless of what follows. Result crimes, by contrast, require D's conduct to produce a specific consequence: death in murder, bodily harm in an assault occasioning ABH. Only result crimes demand the full causation analysis. Knowing which type of crime you are dealing with is therefore the first question to ask when identifying the Actus Reus in any problem question. Here's your check for understanding. Paul is a lifeguard employed at a public swimming pool. He watches a child struggling and drowning, but deliberately does nothing, and the child dies. Has Paul committed the Actus Reus of a result crime? Option A, no. English law never criminalizes omissions. Option B, yes. His contractual duty means the omission can form the Actus Reus. Option C, no. Only voluntary acts count as Actus Reus. Option D, yes. Everyone has a general duty to rescue. The answer is B. Paul's employment contract imposes a duty to act. Because a recognized duty source exists, his deliberate omission can constitute the Actus Reus of a result crime, bringing him squarely within the Pitwood principle. Actus Reus is the physical element of a crime. It can be a voluntary act, an omission where a legal duty exists, or simply a state of affairs. In result crimes, D's conduct must also causally produce the prohibited outcome, both factually and legally. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.